Good day, Crime Talk aficionados. We have a great show for you as we head into the Thanksgiving holiday. First, was Sheriff Mickey Steins kicked out of his home the night before he killed Judge Kevin Mullins? Sean Combs believes the First Amendment covers allegations of tampering. A random act of violence leaves a golfer dead. He was beaten with his own golf club. Will Karen Reed's electronic footprint ruin her defense? Another documentary on the John Bonet matter has raised issues regarding a new suspect based here in Denver. Alcohol can make people do inappropriate things. Let me give you an example. We also have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can check us out anytime on any of your favorite podcasting apps. Now, I don't know if you've noticed, but I feel a lot better today. Still have a little bit of stuffiness, but yesterday was not a great day. Apologize to our Patreon members for not doing our Patreon show and our live show as well. I wasn't going to have any fun, which means you probably weren't going to have any fun either. So we will make it up to you. I promise you. All right, let's go ahead and talk about CrimeTalkSearch.com. Sign up for that background subscription service today. I keep telling you about this. I'm telling you, we just used it this morning in trying to track down an individual that has been avoiding a subpoena. It works, ladies and gentlemen. I wouldn't recommend it to you if it didn't work. So get that background search literally emailed to you while you wait, and it's going to have all the pertinent information you're looking for in a background search. Go to CrimeTalkSearch.com. In the link below, you're going to be happy that you did. All right, today is November 27th as we head into the Thanksgiving holiday weekend. We won't be here tomorrow, which is Thanksgiving, and we won't be here the day after because it's kind of like an official day off here at the Crime Talk studios and the law firm. But let's get to the docket today. Let's open the record as it relates to, yes, ex-Sheriff Mickey Steins. Now, there's been some new information about the case down there in Letcher County, Kentucky, where the former sheriff, Sean Mickey Steins, shot the district court judge, Kevin Mullins, in September in the judge's chamber. Now, there's been some suggestion that there may be some trouble at the Stein homestead. Yes, apparently things were not perfect, to say the least. For those who don't know, the shooting happened in the judge's chambers at the county courthouse where the sheriff and the judge had worked together for years. Now, detectives investigating the scene have confirmed that Steins tried to call his daughter on Mullins' phone and on his own phone just before the shooting. And a grand jury indicted former Sheriff Steins last week on one count of murder of a public official. And Steins, who served as the sheriff for several years, resigned after the September 19th killing at the courthouse there in Whitesburg, which is a small Appalachian town about 100 miles southeast of Lexington near the Virginia border. Now, it is being reported. Take this with a grain of salt. All right, because we don't have this directly coming from Sheriff Steins' wife. All right, but it's being reported that Steins and his wife had some sort of dispute the night before Judge Mullins was fatally shot. All right, the spat apparently put him out of the house for the evening that night. It's being suggested that that was the reason that the sheriff was in plain clothes because he wasn't able to have a uniform or wasn't able to get one to put on for that day. Now, I have seen lots of sheriffs that wear civilian attire. So, like I said, I take this for what it's worth. Take it with a grain of salt, all right? This is a story that lots of people have a very great curiosity for, as do I. I mean, this is a cold-blooded killing. And unless you can come up with some reason that the judge needed killing, and the best you're going to be able to do is maybe some sort of heat of passion, certainly not self-defense, it's cold-blooded killing. And why would a sheriff, the elected sheriff, who's known the judge, personal friend, worked there when he was a bailiff in the judge's courtroom, had just gone to lunch with the judge, shoot him and kill him in his chambers? Obviously, there's been a little bit of dispute, some conflicting information about from different sources as to when things have happened. But some people are saying that the night before the actual shooting, and the sheriff was in a great deal of distress. Now, the call to his daughter minutes prior to the shooting may indicate that maybe things were not exactly having complete marital bliss in the home. Now, the day of the shooting, Steins and the judge attended a lunch together. And though that has been widely reported, there were other people at the lunch. Now, sources familiar with the lunch conversation said it seemed normal. There were no signs of anything out of the ordinary. But when the sheriff attempted to bring up a sensitive subject, which nobody is disclosing what the sensitive subject might be, the judge reportedly stopped him and said, "Let's talk about it in chambers. Come by after lunch." And we all know what happened. We got the video of it, right? Only question was, heat of passion, first-degree murder, killing of a public official. Is there going to be a death penalty, or is it just going to be a life without the possibility of parole type of case? Well, we're going to have to wait and see. Now, the prosecutors have said that it's too early to decide whether Sheriff Steins will face the death penalty, but obviously if he's convicted of murder, that's always a possibility. I personally don't think they're going to do that, but hey, I've been wrong before, right? So the decision will be made in the future whether the death penalty is brought forward or a possibility that the jury would have to consider. Now, the defense believes that they have a compelling story that they hope will complete a defense for Mickey Steins. Now, at an earlier hearing, it was suggested that the appropriate charge according to the defense, would have been extreme emotional disturbance for his client and not first-degree murder. But you have to present some evidence, some mitigation to the district attorney. Now, what will take place is if the defense thinks that they have some excuse, they will present that to the district attorney and perhaps try to reach a plea bargain before this matter actually goes to trial. The prosecution may say, "Wow, that's really compelling. We'll offer you a lesser charge." Or they'll say, "Yeah, not so convinced, but thanks for sharing it with us. We'll see you at trial." It's an interesting story, ladies and gentlemen. We'll bring you the facts and even a little bit of and I don't like to speculate, but a little bit of the speculation. But we have heard stories. It's just trying to get it confirmed that, like I said, it wasn't marital bliss at home at the Steins household. Next on the docket, Diddy says, "Hey, you can't violate my First Amendment rights." That's right. Sean "Did He Do It" Combs absurdly compared himself to the now going to be President Donald Trump in a desperate attempt to be bailed out of jail before Thanksgiving. The rapper's lawyers cited President Trump in a filing pointing out the similarities between their respective legal situations. That's right, between former President Trump, soon to be future President Trump, and Sean Diddy Combs. Diddy's lawyers quoted from an appellate decision from Trump's election interference case regarding the First Amendment. "Only a significant and imminent threat to the administration of criminal justice will support restricting Mr. Trump's speech," the D.C. Court of Appeals wrote in December, as recited by Combs in their pleadings. Lawyers claimed that Sean Diddy Combs has a greater constitutional claim than other trial participants to speak out against the prosecution and the criminal trial process that seek to take away his liberty. Well, the court should, according to them, apply Trump's heightened standard when considering Mr. Combs' speech here in this particular case. Now, the legal briefs were filed in response to the prosecution accusing the alleged sex trafficker, Mr. Combs, of trying to influence potential jurors through a public relations campaign on his child's social media pages. Now, the allegations stem from 7 of his children posting a video marking his birthday on November 4th. His son, Justin, and 6 of Diddy's other kids, including his baby daughter, Love, sat around a birthday cake while they all sang happy birthday to Sean Combs. Now, in the clip, Diddy could be heard speaking in the background, the first time his voice had been heard since he's been taken into custody. Now, old P. Diddy said, "Hey, I love y'all so much. I can't wait to see y'all. I just want to say how proud I am of you, especially the girls. I mean all of you, but just be strong. Thank you all for being strong, and thank you for being by my side," old Diddy said. "I got the best family in the world. My birthday, my I'm happy. Thank you all for giving me the call. I love you. Now, Combs allegedly used an app banned from the Bureau of Prisons called contactmeasap.com to arrange for these videos to be posted online. Diddy allegedly paid off one witness after calling and texting her a staggering 128 times over 4 days from his jail cell to persuade her to support old P. Diddy. Just like the old days, apparently. Anyway, prosecutors also allege he used other inmates' phone accounts to make calls to people he is not allowed to speak with and to avoid law enforcement monitoring. Classic trick. It's done all the time. Anyway, Diddy was federally charged with racketeering, conspiracy, sex trafficking, and transportation to engage in prostitution back in September of this year. Now, the rapper has been accused of arranging these freak-offs described as elaborate and produced sex performances arranged and directed by Combs while he pleasured himself and often videotaped such pleasuring, apparently. Now, he has pled not guilty to the charges, alleging that he coerced and abused women for years, aided by associates and employees, and silenced victims through blackmail and violence, including kidnapping, arson, and physical beatings. Now, dozens of people, some of whom were minors at the time, have sued old P. Diddy in civil court for a various list of allegations, which he has also denied as well. Now, old P. Diddy Combs is currently on his third bid to be granted bail and recently claimed his reputation has been destroyed. Now, in court last Friday, his lawyers argued he should be eligible for bail and he should be allowed to stay in his New York apartment on house arrest. The rap mogul, or I should say the former rap mogul, said that these allegations are aggressive and deceptive media tactics by prosecutors, and they'd already shredded his public image, and only an acquittal could reverse that. Now, Diddy claims the charges that he ran a decade-long criminal enterprise are fictional and that prosecutors were putting a theatrical spin on the truth. Now, he currently remains incarcerated at the Metropolitan Detention Center in Brooklyn after his two previous attempts to be released on bail have been denied. His trial is currently set for May of 2025. My advice, old P. Diddy, keep your mouth shut. Let the lawyers do what they do. You don't need to be attempting to influence anyone, allegedly. Don't talk with anyone associated with your case. You talk about school with your kids. You talk about the weather, but you don't talk about your case. You don't do anything that's going to come back and get you, because as I've said it once and I'll say it again, it is always the defendant's own words that come back and bite them in the butt and usually get them convicted. Next, talk about a horrific random act of violence that got a golfer killed with his own golf club, ladies and gentlemen. This is crazy. Now, Palm Beach Gardens police in Florida said a man in a random act of violence viciously attacked another man with golf clubs before apparently drowning him in a pond at a golf course on Monday. Now, Junior Boucher, Boucher, is being held without bond in Palm Beach County Jail and is facing a first-degree murder charge in the death of Brian Hiddlebeetle. This guy was 65 years old. And this took place at the Sand Hill Crane Golf Club in Palm Beach. Now, the Palm Beach Gardens police responded to the golf course just after 1:30 p.m. on Monday after getting reports of a man attacking another man with a golf club. Now, when the officers arrived, they found Hiddlebeetle's body on the fairway of the hole, and Boucher was running away naked. Now, apparently, Boucher refused to stop, and they tased him. And according to the report, a witness told police he had been playing golf on the hole when he heard a man yelling, then saw Hiddlebeetle retreating from Boucher, who was holding a golf club and was swinging it towards Hiddlebeetle. Hiddlebeetle was yelling, "He's trying to kill me," multiple times. The men then fell to the ground, and Boucher began striking Hiddlebeetle numerous times with the golf club. Boucher then chased Hiddlebeetle towards the pond on hole 1, striking him repeatedly in the head with the golf club. Once the men reached the pond, Boucher jumped on top of Hiddlebeetle in the water and appeared to be choking him, according to the arrest affidavit. Now, the witness told police that Boucher then got off of Hiddlebeetle, who was no longer moving, and retrieved the golf club and struck him repeatedly in the head. Boucher then got out of the water, took off his clothes, and began to walk away. Hiddlebeetle had deep lacerations to the back of his head and was pronounced dead at the scene. It does not appear that Boucher had any legitimate purpose for being on the golf course. So this appears to be a random act of violence where Butcher used his victim's golf clubs as weapons and viciously attacked the victim, ultimately killing him. Now, Butcher had been reportedly missing by the Palm Beach County Sheriff's Office just an hour before. I think from jail, that is. Anyway, in court on Tuesday, the judge denied Mr. Butcher bond and ordered him to have no contact with any witnesses and obviously no weapons if he makes bond. Now, Mr. Butcher ultimately had to admit to the judge that his actual name is Manuel Acosta Rodriguez, so he was booked in under a different name. Now, you may think that's weird, right? But I've seen it happen. I had a guy once that went through the entire proceedings. We kept telling him the name on the charging document is not his name. And the reason why the name on the charging documents were there was he refused to talk to the police, and he had a jacket on that had a name written on the inside. And so they booked him in under the name that was written in the jacket. And I think he had received it from somebody or got it from like a Goodwill store. So go figure. Just be careful out there, ladies and gentlemen. Even the golf course is not safe. Next, Karen Reed. Will her digital footprint ruin her defense? Well, a judge is set to decide whether to release cell phone records that prove Karen Reed had done something terrible on her night her boyfriend died. Now, prosecutor Hank Brennan petitioned the court Tuesday for a release of records of the calls between Reed and her parents in the hours after she allegedly struck Boston police officer, her boyfriend, John O'Keefe, with her SUV on January 29th of 2022. Now, Brennan said that Karen Reed called her parents, Janet and William Reed, several times in the early hours of the morning around the time she claimed she left O'Keefe at a party and drove home. He was found hours later at about 6 a.m. dead in the snow, and guests said that he never went inside the house where she reportedly dropped him off. Now, the inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terribly wrong, the prosecutor argued. She knew she had struck John O'Keefe, and she knew she had left him behind. Now, prosecutors with the district attorney's office claimed Reed's phone records will show that she called her mother 3 times at 1:14 a.m., 4:38 a.m., and 4:42 a.m., and her father at 6:32 a.m. None of the calls were actually answered. Now, at trial, Reed claimed to have been driving around at about the time with 2 friends searching for O'Keefe after he never returned home. Now, she argued that she was the victim of a wide range of conspiracy, including the Boston Police Department attempting to frame her. Now, the first trial ended in a hung jury, and she is scheduled back for trial in January of 2025. Now, although Karen Reed is set to go back on trial in January, Tuesday hearing saw prosecutors and her defense request to push that trial back until April. Now, Reed's attorney, Elizabeth Little, contended that the prosecution's motions for her phone records, she said it was nothing more than a fishing expedition and an invasion of her parents' privacy. Now, she argued that the prosecution has not shown proof that the phone records contain evidence related to the case. Now, the Commonwealth there in Massachusetts is asking this court to sanction this gross invasion of her father's privacy so the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. In one example reported, apparently Miss Reed allegedly made an admission of drinking a vodka tonic every 40 minutes at a bar with O'Keefe on the night of his death. When the audio resumed, court records claimed she offered a non sequitur claiming to consuming sips of water at a second bar while she previously was told 2020. Now, I probably had about 4 drinks and not 4 that I completed either, she said. I don't drink maybe more than a few sips at the second bar. Anyway, Tuesday's hearing, the prosecutor said clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. The judge also did not make a ruling on the motion over the recordings on Tuesday. Reed's next scheduled court appearance is December 12th. Now, Miss Reed has maintained her innocence in the case and says she intends to fight to clear her good name. Like I said, she faces that second trial sometime next year when a final date is set. Now, although the jury was deadlocked, the family of John O'Keefe has launched a wrongful death lawsuit against her, and prosecutors allege that Reed hit O'Keefe with her car following a drunken argument, and she dropped him off at the home of another party and claims to have found pieces of her car's taillight around the body. Now, she had spent the evening drinking with O'Keefe and a group of friends at the Waterfall Bar and Grill in Canton, Massachusetts, around 14 miles south of Boston. And the group were invited to the home of their friends, Brian Albert, who is a retired Boston police officer. Now, Reed, who prosecutors say drank several alcoholic drinks beforehand, decided to drop O'Keefe off at the after party before she went back to his home that she shared with his orphaned niece and nephew to go to sleep about 1 a.m. in the morning. Now, court documents reveal that the couple had been arguing for weeks beforehand, and on the night that O'Keefe died, Reed left him a voicemail calling him an effing loser and John, I effing hate you. Now, the couple had been dating for 2 years at the time of O'Keefe's death, and he had been serving on the Boston Police Department for 16 years. As the party went on inside Albert's home, Reed said that she woke up around 4 a.m. to find that he was not home yet, and told O'Keefe's niece that she was in fact quite distraught. Attendees at the party, including some law enforcement, claimed that O'Keefe never made it inside the party or entered the home. Reed then searched for O'Keefe with a friend, and prosecutors alleged that during the search, she told her, "What if he's dead? What if a plow hit him? I don't remember anything from last night. We drank so much, I don't remember anything." At 6 a.m., Reed allegedly found O'Keefe laying in the snow outside of Albert's home, and a first responder on the scene reported claimed that Reed repeatedly cried out, "I hit him, I hit him." Now, O'Keefe was rushed to the hospital where he was pronounced deceased, and the autopsy found that the cause of death was blunt impact injuries and hypothermia. Now, Reed's defense countered that she is the victim of an extensive conspiracy to frame her, and claimed that the other officers and attendees at the parties are the ones who actually attacked the police officer where he was found dead. Now, Reed claims that she was framed and drew a legion of fans who wore pink to show their support for her outside the courthouse. The judge also issued an order to state that the trial banned supporters from coming within 200 feet of the courthouse. Reed's courthouse behavior also sparked a little bit of controversy, as she was branded America's happiest murder defendant, as she appeared to soak up the attention while winking at the camera and eating snacks in court. There you go, ladies and gentlemen. The latest on the Karen Reed matters. Once again, keep your mouth shut. Why is she going on 2020? Changes in the audio, perhaps. I mean, we know they, allegedly the news media has been known to edit things. So that does become relevant if it was edited from alcohol to water. But once again, more prior inconsistencies that Karen Reed may have to be cross-examined on. Anything she says comes in as an admission as a party opponent. It is not hearsay. So shut your mouth. I don't get it. Keep your mouth shut. You're not going to win your case in the court of public opinion. Trust me, it doesn't work. Next on the docket, there's another JonBenét documentary on Netflix, and I have to admit, I started watching it, and then I fell asleep because I wasn't feeling well, but I'm going to get back to it. Anyway, the convicted pedophile who claims that he may have accidentally killed JonBenét, well, they thought he was missing, but apparently he's not missing. So Gary Oliva has said for years he was in the Ramseys' home back in December of 1996 when he, quote, "I let her slip and her head bashed in half and I watched her die," end quote. Olivia wrote that to a high school friend back in 2019. Now, when police investigated the case, his name came up and they found hundreds of pictures of JonBenét apparently in his possession. Now, Olivia had also confessed to other killings, but has never been charged with those killings either. He did serve 8 years in the Department of Corrections for the possession of inappropriate child images. Now, he's out on parole and will be on parole until February of 2027. Now, during an investigation back in 2019 into JonBenét's murder, Olivia was already locked up, but apparently was eliminated as a suspect because his DNA did not match the evidence at the murder scene. However, some people have said the DNA technology has advanced and maybe he should be considered. Now, we're not saying he did anything wrong. Yes, there's a statement, but people confess to things all the time. Anyway, we give him the presumption of innocence because we don't want to get sued, right? Anyway, the timing here is interesting. All this stuff coming about because of the new Netflix series Cold case. Who killed John Bonet? The documentary raises the question as to why Olivia has been eliminated as a suspect, even with some unreliable DNA evidence. Now, like I said, Gary Olivia is not actually missing. Now, there was a story published earlier in the week, and officials realized a clerical error had been made. Apparently, his current address had not been updated in the state's sex offender registry. Apparently, he had been somewhat transient and had not been checking in. But apparently, mystery solved, ladies and gentlemen. I'm sure that interests everybody. I don't know. John Bonet, the story that won't go away. Maybe I'll be in Boulder this weekend and we'll drive by the John Bonet house again. It's not hard to find. It's right there near the Chautauqua Park in Boulder, on the way to the CU game to see if they make it to the Big 12 championship. We'll have to wait and see, I guess, on everything. Alcohol can make you do some very inappropriate things. Let me give you an example of one. So, some newly released body cam footage shows an Illinois Democrat by the name of Samantha Steele rolling her eyes and dropping the fact that she is an elected official as Chicago police officers placed her under arrest for drunk driving. The Cook County Board of Review commissioner that if she does not exit her car, he will help her out, warning her, you don't want to do that. You don't want that. Steele fires back. Matter of factly, I'm an elected official. Steele then nods smugly at the officer before telling him that she works in Cook County. Really? When asked which office, she appeared to give a nonchalant shrug before seemingly rolling her eyes at the officer's question. Now, the Democrat elected official who works in Cook County can be seen stumbling and slurring her words in the footage, also repeatedly asked the officer if his penis was that small during her arrest. That's one way to win hearts and minds, isn't it, ladies and gentlemen? Anyway, Miss Steele was stopped by police after she apparently drove into another vehicle on a Chicago street earlier in the month. Now, both cars had extensive damage, while Steele's eyes were bloodshot and glassy, and she smelled of an unknown alcoholic beverage, according to the police reports. And officers also saw an open bottle of red wine on the passenger side floor of Miss Steele's car, and the commissioner refused to perform roadside sobriety tests. Now, during her arrest, Miss Steele repeatedly said, "Is your penis that small?" to an officer. When asked how much she had to drink, Steele shot back, "I want my lawyer, and I'm not talking to you." Now, Miss Steele was ultimately arrested after complaining of a head injury and being taken to the hospital in an ambulance. She was charged with one misdemeanor count of driving under the influence of alcohol and is due in court on December 27th, just a couple days after Christmas. You got to love that. Anyway, Miss Steele, who represents the Board District 2, which includes most of Chicago's north side and surrounding suburbs, was first elected by the board back in 2022. I think she should resign. I think public officials need to be held to a higher standard. Now, obviously, she's given the presumption of innocence. She hasn't been convicted just yet, but I'm thinking she's going to be convicted of drunk driving. Unless, of course, well, she works in Cook County and people don't show up for court or the evidence gets lost. Who knows, ladies and gentlemen? Alcohol makes people do embarrassing things sometimes. Sometimes it can also be a truth teller, little truth serum anecdote, so to speak. But a truth serum, it can also be a little bit of a truth serum sometimes, as people say things that they maybe wouldn't otherwise say if they were not drunk. Be smart out there, ladies and gentlemen. I got a little bit of free legal advice for you. Don't drink and drive. Yes, it's not illegal to drink. It's only illegal to drink and drive over the limit. My suggestion is if you have one drink, don't drive. Get an Uber. Have a friend. Don't go to jail. And if you do get stopped, be polite to the police officer. Even if you think you are completely innocent, be polite. If you're totally sober, go take the test. Think about it, ladies and gentlemen. But don't be rude to the police officer. That will be a factor at sentencing if this elected official gets there. Assuming since she works in Cook County, the evidence doesn't disappear. Next on the docket, how about this day in legal history? That's right, on November 27th, 1968, Sirhan, the assassin of Robert F. Kennedy, was found guilty. His act had an effect on the political climate and led to debates on gun control and security. Then the Warren Commission, that's right, the post-assassination of JFK on November 27th, 1963. President Johnson authorized the Warren Commission to investigate the events, resulting in a major legal report on conspiracy theories. I mean, come on. Release it all, ladies and gentlemen. Release it all. Everyone's just about dead except for, I think, one lady who knew Lee Harvey Oswald, and she's still alive. Some people say she was involved. I don't think she was. I don't know. Release all the information they have. Everybody's dead. We're entitled to the truth. I'm so tired of the government thinking we're all a bunch of idiots. And then on November 27th, 1976, the Supreme Court upheld state death penalty laws under strict guidelines, reshaping capital punishment in America. What does that mean? Super due process, ladies and gentlemen. As you may recall, prior to that, the Supreme Court had said that it was cruel and unusual punishment. A little bit of change in the court structure. Went back. It's not cruel and unusual punishment as long as you get super due process. And then on November 27th, 1991, after being sentenced to multiple life terms for the murder of 17 men. And finally, Jeffrey Dahmer's sentence. That's right, Jeffrey Dahmer, one of America's most infamous serial killers, continued to draw attention on November 27, 1991, after being sentenced to multiple life terms for the murder of 17 men and boys. And if you've ever seen anything, all that stuff about Dahmer, creepy. My God, just picking up people, putting them in vats of stuff in his apartment and chopping them up. Some people are just not wired right, ladies and gentlemen. They need to be identified early and often. Taken off the streets. Just something to think about, all right? And finally, take a look at this. This video went viral from Waco, Texas. It shows a group of thieves working together to yank an ATM out of a Waco convenience store. Now, obviously, as you can see from the video, these three men in the video were using a stolen truck out of Waco, Texas. The stolen ATM and car used in that theft were found dumped nearby later that day. And as you can see, the dumb criminals didn't get away with anything, but they got arrested. There you go, ladies and gentlemen. All right, that's all we have for you today. We're heading into the Thanksgiving holiday. We'll see you next week. Have a wonderful day. Enjoy your holiday. And remember, the Constitution matters.